morning, everyone. Thank you very much for joining our webinar. I can see that the numbers of attendees are ticking up as I speak, so we will hold on before formally introducing. I'm merely speaking now so that you know that this is the right place to be. If you're here for entitlements for children and young people with SEND during COVID-19, you're in the right place. Absolutely delighted with the numbers of people who've expressed interest in today and have booked on, and we're expecting to have over 500 people on the webinar. So it will just take a moment to see if everyone is able to get online. Numbers are still ticking up. Okay, we'll make a start. Well, thank you ever so much, everyone, for joining this 39 Essex Chambers webinar on entitlements for children and young people with SEND during the current public health crisis. My name's Steve Broach, and I'm joined by my colleague Tom Amraoui, and we are going to present on the very recent changes to the law on entitlements for children and young people with special educational needs and disabled children and young people. In particular, Tom's going to speak about the amendment regulations, which change the timeframes for various stages of the Education, Health and Care Plan, the EHC Plan process, and also share some experience of trying to be involved in remote hearings during this process as well. I'm going to then talk about the Secretary of State's notice, which amends Section 42 of the Children and Families Act and turns what was previously an absolute duty to secure and arrange provision into a reasonable endeavours duty, and then share some thoughts about children's social care in that context. So that's the agenda for the morning. We've got an hour. We're going to try and speak for no more than 20 minutes each and leave time for questions. In terms of some logistics, I'm sure people are pretty familiar now with how these kinds of webinars work. At the bottom of your screen, you should have a Q&A button. And some people have already begun to ask questions, which is really helpful. Tom and I will try to do a double act. And as the webinar goes on, whichever of us isn't speaking at any particular moment, we'll try and answer the questions in writing. I would love to be able to answer some of these ones that are coming in as I speak, but I haven't quite worked out how to do that yet. So I'm going to leave these for Tom, but then Tom's going to speak first. So it may be that I can immediately start typing. Those that we think might be of wider interest, we'll flag to answer orally once our presentations are finished. So please do ask questions in there. Should stress, of course, please do ask general questions. Neither Tom nor I can give any advice in this session. So please do try and ask questions that are going to be of general interest and for general information. And also, if anyone's struggling with the technology, of course, we are very grateful for the assistance of colleagues in chambers behind the scenes. You can ask questions on the Q&A in that respect. We are recording this session. I can see it says so at the top of my screen, and it will go on our website with the slides. The 39 Essex Chambers website will have both the presentation and the slides. So if you're missing anything, don't worry, you'll have another chance to look, and you don't have to try and write everything we say down. I think that's all I need to say by way of introduction, and I'm now going to hand over to Tom to start the session looking at the amendment regulations. Over to you, Tom.
Thank you, Steve. So as Steve said, my presentation is going to cover two broad issues. The first, as Steve said, are the amendments, the amendment regulations, which have to do with the timescales of EHCP processes. And that's going to take up the lion's share of my talk. And then at the end, I just wanted to share some thoughts about hearing practice and procedure in the tribunal in the current environment. So going to the first topic then, the key documents that you would want to be looking at are obviously the regulations themselves. These I'll refer to as the amendment regulations throughout this talk and throughout all the slides that are going to follow. These are very much hot off the press. They only came into effect on the 1st of May. So we are all, to some extent, scrambling around to work out the implications of them. We are helped to some extent by guidance that the government has published. That was published on the 30th of April, and it has the not very snappy title, Education, Health and Care Needs Assessments and Plans, Guidance on Temporary Legislative Changes Relating to coronavirus. It is published on the Department for Education's website, and it is fairly user-friendly guidance. It is worth noting that it's not statutory guidance, so it's not strictly speaking legally binding, but it is of course expected to be followed by local authorities, by schools, by other statutory bodies, and will be useful to all practitioners in this field, and of course to parents. So the main themes then of the changes. First point is that it is only some aspects of the law on EHC, needs assessments and plans, that have changed, and they have changed temporarily. Where this hasn't happened, the underlying law has not been disapplied. The basic duties have not been, in the government's words, turned off. And that quote that I've put there in the first slide is directly from the government's guidance with some emphasis added. Where there is a key change, it is to the timing. So what we see with these amendment regulations is a very significant relaxation of the deadlines for various aspects of the EHC process with which we have all become familiar. Another way of putting it is local authorities have basically been given completely new grounds, quite extensive grounds, in which to delay doing various things that they would customarily have to do with strict timetables, where the delay is due to coronavirus. As to the duration of the regulations, I've already mentioned that they came into effect on the 1st of May. They expire on the 25th of September, so they're enforced between those dates inclusive. They are enforced now, but not, so far as we know, beyond 25th of September unless they were to be extended. Note as well that there is a duty within the regulations themselves, in Regulation 2, for the Secretary of State to review their effectiveness during the period in which they are in operation. So the overview there is that this is the regime we're all going to be under at least until the 25th of September. The crux of the regulations, it seems to me, is what is called, or what at least I'm going to call, the Coronavirus Exception. So in terms of what the regulations do legally, is they modify 4 different sets of regulations which deal with timescales applicable to local authorities, health commissioning bodies, and others. The most important set of regulations that they amend are the 2014 SEND regulations, which practitioners will be familiar with. And again, the change is a relaxation of the various time periods applicable under those regulations, where the so-called coronavirus exception applies. So to give you an idea of how this works, Regulation 5, and I've put the wording here on the slide, inserts a new Regulation 2A into the 2014 regulations. And I think this wording is quite useful because it's an illustration of what the government is doing here. So where the coronavirus exception applies, any requirement in any of the regulations specified below for action to be taken within a specified period of time, in other words, by a deadline, is to be read as a requirement instead for such action to be taken as soon as reasonably practicable. Those words, of course, are in bold because that's the new requirement that's going to apply. And number 2, coronavirus exception applies where it is not reasonably practicable for a person to meet a requirement referred to in paragraph 1 for a reason relating to the incidence or transmission of coronavirus. Now, I've highlighted those last few words, Regulation 2A, quote, for a reason relating to the incidence and transmission of COVID-19. And it is probably quite an obvious point, but I think it's worth emphasising. This isn't, as it were, a free-for-all or a free rein for local authorities to blast past the normal deadlines for reasons other than those related to COVID-19. So if there is going to be any slippage in the timetable applicable to the various processes of EHCP assessments and planning, it must be pinned down to some reason that has to do with the current health crisis. Nevertheless, it seems to me, just with my lawyer's hat on, that the wording here is pretty broad, and on any view, this is giving local authorities some very significant new leeway and wriggle room. In terms of the deadlines which are actually modified by this coronavirus exception, they are very extensive, and this talk, or at least my part of it, is not an attempt to set out all of the changes. If you want to look at a more comprehensive list, the government has published helpfully an Annex A to the guidance, and that sets out the key timetables, timescales that have been amended by the regulations. but focusing on those which are most likely to be of interest to practitioners, to parents, to local authorities. The list is very extensive, so it's the determination of requests for needs assessments, it's decisions about whether or not to issue a plan at all, and it's about the various stages of preparing and then issuing EHCPs. It's also the annual review of EHCPs, and I'll come back to that in a later slide. It's the processes relating to mediation in respect of appeals, and it's then, for example, the actions that a local authority or a health commissioning body would be expected to take when the tribunal makes its non-binding recommendations under the national trial, which continues. So, as you'll see from just that list, that's a fairly broad swathe of deadlines applicable in this area of law. And I've given in these slides two examples, which I'll run through now. The first is the 20-week timetable that most people in this webinar will probably be familiar with. So that's the 20 weeks following a request for an EHCP needs assessment, all the way through till the local authority actually issuing the final plan. So the previous position was 20 weeks statutory deadline. How is this affected by the amendment regulations? Well, they say if the incidence or transmission of COVID-19 makes it impracticable for the local authority to meet that deadline, it must discharge the duty, quote, as soon as practicable. So right there, there's a relaxation of the deadline where the coronavirus exception applies. Another example is annual reviews. So the Coronavirus Act 2020, which is the parent legislation, and I know that Steve is going to be talking about one particular notice that's been issued under it, does include a power for the Secretary of State to issue a notice temporarily disapplying the duty to conduct annual reviews at all. Now that hasn't been invoked, so the duty hasn't changed. Annual reviews do still need to take place. However, there's a very significant caveat to this, because the amendment regulations create what seems to me, in effect, a new delay excuse for local authorities. So, where it is impracticable for the LA to complete an annual review within the prescribed timescales, so for example, the 12-monthly annual review, the normal timetable created by the Children and Families Act, because of the coronavirus exception, then the local authority must instead complete it as soon as reasonably practicable. There are those words again, and there we see that loosening of the timetable, a new excuse, a new grounds on which delay is allowable. So those are two concrete ways in which the amendments change the timetables. Of course, the question that is on everyone's minds is how big of a change really is this? How radical is it? And it seems to me that this is, whichever way you look at it, a very extensive relaxation of the deadlines that would normally bind a local authority during all of the processes that we're familiar with EHCPs. And it must be right that if this so-called coronavirus exception is used frequently over the coming weeks and months, now that the regulations are enforced, then the impact is going to be radical. And I think the reality is that, combined with the disruption that there is to regular schooling because of school closures, there is at least the potential for a lot of cases to slip with the timescale. Again, the underlying duties are not changed, but the timetable within which things must be done has been potentially very radically loosened by these regulations. At the same time, it's important to realise what hasn't changed. So, as I say, the substantive requirements of the law haven't changed. There is no relaxation of the duty to consider new requests for needs assessments. Where the local authority is going to carry out a need assessment, then it still has to go through the work of getting all of the advice and information from schools and others that it would normally have to bring in order to determine whether a plan is needed. And again, in respect of annual reviews, those do still need to go ahead. There's no change to the duty to hold those, to consult, but of course the timetable has changed. Interestingly, and I think importantly, one timetable or deadline that the regulations don't change is the 15 days during which parents or young people must be given a chance to make representations on a draft plan. That is still in force, and that must still be adhered to. And lastly, it's also worth recognising that under the existing regime, there were already grounds on which local authorities could allow the timetable to slip. So practitioners might be familiar, for example, with the exception to the 20-week time limit for plans, where various grounds were given for local authorities to go past that deadline for a variety of reasons, including, for example, exceptional personal circumstances affecting the child or the parent. What these new regulations have done is added a completely new and additional ground to local authorities to delay. So that's, broadly speaking, what is going on legally. In terms of lawfulness and good practice, I'm not going to give an opinion about whether the regulations themselves might be vulnerable to challenge. But I think what we can say is this. Local authorities should not be, as it were, casually invoking this exception just because it is in place temporarily. It shouldn't become the norm. There might be doubts about the lawfulness of doing that, but I think just on a practical basis, it must surely be in the interest of everyone not to have a massive, as it were, build-up or logjam of decision points that come through once this new regime is lifted. So the normal work of EHCP assessments, reviews, plans and so on, all of that needs to keep going as far as it possibly can. And I do think it's not going out on too much of a limb to say that if there is any blanket approach by local authorities to saying we're simply not going to meet the deadline at all, or we're not going to do so in a particular class of cases, then that blanket approach is very likely, I think, to be amenable to challenge in the courts. In terms of good practice, again, I would refer you to the guidance. There is some helpful guidance on this. The government seems to be hopeful that local authorities might find creative ways of ensuring that deadlines are met. And I won't go through the whole quote that I've got there, but the basic thrust of it is to encourage virtual working. For example, that you might have virtual meeting platforms to assist with decision making. Annual reviews might be conducted in that way. So there are some suggestions about how this can work without breaching the timetables. But of course, this is very much a new world and we need to wait and see what happens in practice. Last but of course not least, there are likely to be questions about what about EHC processes already underway when the regulations came into force. And again, the key date here is the 1st of May. That's when the amendment regulations came into force. They didn't do so before, they're not retroactive. So if, for example, the final deadline had passed before the 1st of May, then just because local authorities can now relax the timetable, it doesn't mean that the timetable can be relaxed for those processes. Simply put, the coronavirus exception didn't apply then, the regulations weren't in force. It will be different, however, I think, for new requests, for example, for EHC needs assessments. If one of the processes was already underway on the date on which the regulations came into force, in that instance, if the relevant exception to the timing in the regulations applies, then it could well be that that stage of the process is delayed, and unfortunately, later stages of the process can also be delayed if, again, the local authority can rely on the coronavirus exception. As to this, the guidance doesn't say a whole lot, unfortunately. It does say it will depend very much on the facts of the case. Again, that doesn't take us very far, but it does suggest that any blanket approach is to be avoided and is likely to be challenged in the courts. I'm conscious of time, so I'm going to run through very quickly tribunal practice. Many of you will be familiar with this because this new regime has been operating for a number of weeks. The two basic points are, first of all, parents' rights of appeal to the tribunal are not affected by any of this. Those are still intact and they are able to be exercised and should be exercised. What has changed is the way in which the tribunal worked. So as many of you know, essentially from late March onwards, the tribunal has moved to fully digital working. So no face-to-face hearings. That was initially for a period of 3 weeks, starting on the 23rd of March, with the expectation it would be reviewed over Easter. This appears to be continuing, and I've read guidance over recent days that suggests that this is going to be in force for 6 months. So it is likely that this pushes all the way through until September. Again, the basic principle is cases dealt with either on the papers or by telephone or video link. This carries a number of practical implications, and here are some suggestions I've put in this slide. I don't think there's any magic in any of this. I think one particular difficulty in the SEND jurisdiction is going to be around working documents, because as many of you will know, it is not at all uncommon to have last-minute discussions on working documents literally at the door of the tribunal. That, of course, is not going to be possible in a virtual hearing. So any discussions on working documents should take place remotely, either by an exchange of emails, telephone conference, video conference, in good time, well before the final hearing of an appeal. Of course, it's also not going to be possible for parties to bring hard copies of late evidence. There's very often late evidence in these cases, but e-filing is still possible. So documents can be sent in by email, and the tribunal will, in the customary way, deal with applications for late evidence at the start of the video hearing. I've queried whether adjournments are going to be more likely because of difficulties with witness availability directly due to COVID-19. I personally haven't found this to be too much of a problem, and hearings are going ahead, thankfully, but it's something to watch out for, given that schools are closed and there may be difficulties with witnesses, including school witnesses, expert witnesses, being themselves not available because they're ill or for other reasons. For what it's worth, my overall impression, having done a number of these hearings over recent weeks, is that the tribunal service has coped reasonably well, at least as well as can be expected. It is a little clunky. There are often technical glitches and so on, but overall it is working, I think, better than expected. So that is a ray of light that we can take away. That concludes my presentation. I hope it's been informative, and I'll hand over to Steve next.
Thanks very much, Tom. It was certainly, in my view, helpful and informative. Thank you ever so much. And I particularly endorse the message you were giving about local authorities not looking at this as some kind of carte blanche to not do anything, of course, but to rigorously consider whether in the particular case the grounds that are given in the regulations do apply to allow things to take longer. That's how they're intended to be used. So I'm going to move on now and try and share my screen. Let's see if we can do this. I think you need to give me back control of the screen, if that's okay. Yeah. Are you able to do that?
Yeah.
Great, thanks very much. And I will bring up my slides, which focus on the Secretary of State's notice. Hopefully everyone can now see my slides on the screen. And so it's important to bear in mind what this notice does. It amends the core duty in section 42 of the Children and Families Act, which is one of the two pillars, really, of the legal entitlements for children and young people under the Act. The second being the duty in section 43 to admit children and young people into the school or institution that's named in section I of their plan. Section 42 mandates that local authorities and political commissioning groups, in essence, possibly NHS England, must either secure or arrange respectively the special educational provision that's specified in section F of the plan and the healthcare provision that's specified in section G. And so working together, those twin duties mean that when provision is set out in section F or section G, it must be made. And there's a very helpful quote from an old case, Ennan North Tyneside, which was decided under the previous scheme for SEN under the Education Act 1996, but is still relevant in my view, where Lord Justice Sedley said that there is no best endeavours defence normally for a failure to secure provision that's now set out in an EHC plan. There's a machinery for revising what was then the statement but would now be the plan, but while it stands, it's the duty of the local authority now to implement it. In some cases, a court might not make a mandatory order because the court will not normally order a public body to do something that's impossible, of course. But what they might do instead, as Lord Justice Sedley suggested, is defer or qualify that order to recognise that in particular situations, it may not be possible to comply with the duty. But otherwise, if it's possible to secure or arrange the provision, it must be done. And that's crystal clear. And it's the most significant form of duty that's available really in social welfare law. It creates an absolute entitlement to that provision unless and until the plan is changed. So that's where we were up till the 30th of April. But on the 1st of May, the notice kicked in. So this is, the snappy title is on the top of the slide. I won't read it all out. Let's just call it the Secretary of State's notice. And we can see in the italicised text that what happened in the notice was that the Secretary of State, by that notice, modified Section 42 of the Children and Families Act. Well, hold on a minute. How did he do that? He did that because he was given the power to make a notice modifying the duty by the Coronavirus Act 2020. So in the schedule to the Coronavirus Act, there was a power for the Secretary of State to make a notice which would modify a range of different statutory provisions. And the one that he's decided to modify so far, at least, is Section 42. And we can see that the modification is that any duty imposed on a person by that section, so that means local authorities and generally CCGs, is to be treated as discharged if the person has used reasonable endeavours to discharge the duty during the period specified in this notice. So the period at the moment is May, but of course it could be extended. And what's very obvious from the beginning here is that unlike the regulations that Tom's just described, this is not supposed to be a case-specific decision. This is of general application. So at all times now, for the duration of this month, a local authority or a CCG has complied with Section 42 of the Children and Families Act if they've used reasonable endeavours to secure or arrange the provision that's set out in the child or young person's EHC plan. So it's a very striking change, and it's a very unusual example of a minister being able to amend primary legislation, albeit for a very limited period, through the use of an instrument like this. The notice has some useful information in it, which is mandated by the schedule. So first of all, it says that the Secretary of State has formed the view that it's appropriate and proportionate to introduce the notice because of these reasons. So first of all, because local authorities have reduced staff resources. Now, I'm not going to quibble with every point the Secretary of State makes, but it is, I think, interesting that that's the first reason given, because of course, most of the resources that are used to secure and arrange provision are not necessarily those of the local authority at all. But in any event, that's the first reason that's given. Secondly, it said that children and young people in many cases are being educated at home. But again, that doesn't always mean that they can't have the provision that's set out in their plans. Normal educational programs for them are probably disrupted, and some clinical commissioning groups have had to redeploy staff or reprioritise services. So the reasoning that's given in relation to why it's appropriate and proportionate to make this notice is, I would suggest, put at quite a high level with not very much detail. Secretary of State has also expressed the view that there's no alternative to making the notice, and the particular alternative that's been considered is the possibility of remote delivery of support because of these reasons. So first of all, there's unlikely to be sufficient specialist staff to deliver all provision remotely. Some provision may not be possible to deliver remotely, and that's obviously right. So if a child or young person has that they should be educated in a group of 4 or 5 other peers in their plan, it's clearly not possible to deliver that provision remotely. But other types of provision, for example, the therapies, it may be possible to deliver remotely. And then I've quoted this in full. Even if a remote equivalent were to be provided for each aspect of provision specified in a plan, this would not constitute securing the provision as specified, which, as a lawyer, I accept. But you might think that a pragmatic approach could be taken, and that the Secretary of State could have formed a view that people would deliver the best fit provision in a way of discharging the duty. But that's not now what they're required to do. They're supposed to use their reasonable endeavours to secure or arrange it. And then the Secretary of State's also expressed a view about proportionality and said that the modification allows local authorities and CCGs to adapt to the changing situation in their specific area based on the nature and demands of the outbreak locally, etc. But importantly, and the needs of each individual with an EHC plan. So there is supposed to be consideration, as we'll see in the guidance shortly, of what this all means for the young person, the child, the family, because at its essence, proportionality requires there to be a fair balance between competing interests. And so the needs of the child or young person and their family must remain central to the decision as to what is a reasonable endeavour in any particular case. And then it said the modification enables local authorities and CCGs to arrange reasonable alternatives to the service during the outbreak, and identifies the example I've given, delivering therapies remotely or using video. So now we have the guidance, and I'm going to break off here just to show you the guidance quickly. I thought that might be more helpful. The slides will of course be available online, and you will be able to look at them afterwards. But I'm going to come out here, hopefully this will work, and I can then bring up the guidance itself. So that's the notice for those who wish to see it. It's not particularly significant. Oh, in classic fashion, my guidance has gone. Right, I'll try and find it here. Bit of luck, this is now going to bring it up. There you go. Through the wonders of a popular internet search engine, here is the guidance. And we can see that it's relatively short. As Tom said, it's non-statutory. But it is, of course, persuasive and should influence local authorities. And we can see that it's described as being guidance on temporary legislative changes relating to coronavirus, and helpfully sets out the notice and the regulations, although it doesn't link to the regulations. You can find those through a search as well. The first part of the guidance considers the regulations. But before we get there, a very helpful section in the guidance on the importance of co-production, reminding all concerned that it's even more important at this time that local authorities, etc., are working with families to identify appropriate ways forward, and the fundamental principle of co-production within the system. And we can see in this section here that where the changes in the law affect what families experience, they need clarity. Families need clarity as to what they're going to get, the reason for any difference, and what from the plan, and what decisions will be made as part of the various processes. So this should all be done in a transparent and cooperative, collaborative way. Sorry, I'm first, I'd forgotten that. So the first thing that's covered in the guidance is the reasonable endeavours duty. And we can see here a short summary of the notice and what it does. And it is important, as the Secretary of State notes here, that the notice does not absolve local authorities or health commissioning bodies of their responsibilities under Section 42. And what's described, we have a definition or an attempt at a definition of what using reasonable endeavours means. The guidance says this means that local authorities and health bodies must consider for each child and young person with an EHC plan what they can reasonably provide in the circumstances during the notice period. And so, of course, the answer for some children and young people might be everything. It may be reasonable to provide everything. For others, it may only be a modified form, and possibly, although the guidance doesn't really contemplate this, the answer might be nothing. And we can see a very important point, that once the notice expires or is cancelled, local authorities and CCGs would in all cases need to secure or arrange the full range of provision as specified in the plan. We then get some guidance on decision-making processes. And we've seen some of the reasons why it may be difficult to arrange already from the notice itself. But then the guidance says that local authorities and CCGs should consider these factors when deciding what provision should be secured or arranged. So the specific local circumstances, as identified, the needs of and specific circumstances affecting the child or young person. So that's quite an important point. And essentially what local authorities and CCGs are being told is, it may be difficult for you to arrange this provision, but if it's really important for the child or young person to receive it, it may still be reasonable for you to make that happen. Whereas if the provision is less important at this time, then it may be unreasonable for you to go that far. That's what I'd suggest that balancing exercise here requires. And very importantly, of course, the views of the child, young person and parents themselves over what provision might be appropriate. And there should be records kept in an individual case. So a local authority and health commissioning body should keep a record of the provision it decides it must secure or arrange, and then confirm what's been decided and explain why the provision differs from that in the plan, and keep it all under review because things might change. So it's designed to be a duty that accommodates quite a fluid situation. And very importantly, and this addresses a number of the questions that have already been asked, and I think this part of the guidance needs to be well circulated and well remembered. The modified Section 42 duty relates to the provision for each individual child and young person. Local authorities and CCGs must not apply blanket policies about the provision to be secured or arranged. And to pick up a theme from Tom's talk, I suggest they also must not apply blanket policies to any changes in timescales or certainly refusals to carry out various stages of the EHC process. Everything here is supposed to be focused on what's possible, what's reasonably practicable, to use the other language in the regulations, in an individual case. There's then a framework that's been given to help local authorities and CCGs decide what's reasonably practicable in a particular case and what reasonable endeavours would mean in that case. So there's the recognition again that in some cases, the answer might be everything at the top of this section, but where the full provision can't be delivered or delivered in the way described in the plan, they should use the framework below to decide what can reasonably be secured or arranged. And three things to focus on: the provision that the plan describes, the availability of the people who normally deliver it, and what can be done to deliver provision differently. And then we have these questions that local authorities are invited to ask, which I've put on the slides. You can see it's what provision, where can it be provided, how can it be provided in terms of frequency and timing, when might it be provided, and by whom. So those are the questions that public bodies are invited to ask. And then we have some helpful examples of alternative arrangements that might be made to deliver provision differently, and a very lengthy list, in fact, of examples of alternative arrangement. So the nature of a reasonable endeavours duty is that it will be a requirement to do what is reasonable in the circumstances of that case. So these are not supposed to be exhaustive. These are merely examples of things that could be done to secure or arrange some provision, even if not everything. And then we move on to the guidance on this, on what Tom's already described, which is the timescales point. So I'll jump back to my slides now. And you can see I've picked out a few of the aspects of the slides. I won't talk to these because we've just gone through it. There's the list, there's the framework for reasonable endeavours. And let me just focus a little now on some implications. So the first point I would make is that a response from a local authority or a CCG that says, well, we're not doing anything to secure or arrange this provision would seem to me at least to be plainly unlawful, bearing in mind that neither Tom nor I are giving any advice today. But in general terms, I would say that a do-nothing approach is not consistent with the language of the notice and the legislation, or certainly not with the guidance, which doesn't seem to recognise that nothing is ever going to be an appropriate response, although I think as a matter of law it might be. So local authorities and CCGs should try to secure provision as set out in sections F and G of the plan, whether as specified or in some other modified form, always working with the child or young person and the family as to how that could best be done. Can a local authority or a CCG be challenged for a failure to exercise reasonable endeavours? Yes, of course they can. That would be amenable to judicial review on any recognised public law ground. But to show that it would be, for example, irrational is going to be difficult, because you will have to persuade the court that the local authority's view that they've carried out what is their reasonable endeavour in that case is unreasonable. It's going to be a high threshold for any successful challenge. So in practical terms, if what this notice does is mean that local authorities and CCGs are providing less for children and young people with significant special educational needs, what will happen? Well, I'd suggest that the responsibility to meet those needs is going to fall back on schools. And it's important to keep in mind that Section 66 of the Children and Families Act imposes the duty on local authorities, on schools and colleges, other institutions, to use their best endeavours to secure the special educational provision that children and young people require. And to pick up Tom's point about backlogs in terms of timeframes, there's a real risk, I think, that when children and young people are going back to school and colleges, that the schools and colleges will find that they are expected to do more, or at least use their best endeavours to do more, and keep in mind their reasonable adjustments duties under the Equality Act, in a situation where they are already under very significant pressure. And so this is another reason why I'd suggest local authorities and CCGs need to do as much as they can to continue to make the provision themselves. And the final point to note, and I think this is really important, is that there's no change at all to the social care duties to disabled children. Now, there are a controversial set of regulations that amend various aspects of the Children's Social Care Scheme. one of which is directly relevant here, which is the safeguards in relation to disabled children who have overnight short breaks. But in terms of the core duties to assess and provide social care for disabled children, they're not affected by this notice. And that's because Section 42 of the Children and Families Act doesn't cover social care. It's concerned with education and health. So just very quickly, in a couple of minutes before we go on to questions, what are those core duties? Well, I'm sure most, if not everyone on this webinar understands that every disabled child, in that broad definition in the Children Act 1989, is a child in need. And all children in need are entitled to some form of assessment in accordance with the implied duty in Section 17 of the 1989 Act. And that assessment must be completed in accordance with the Working Together to Safeguard Children statutory guidance, unless the local authority's taken a considered decision to do it differently, which is very unusual. Once the assessment's been completed, the question as to whether or not there's a duty to provide services to the child is usually answered by reference to Section 2 of the Chronically Sick and Disabled Persons Act, the CSDPA 1970. And in essence, the legal question is whether it's necessary to meet the child's needs by providing one or more of that listed range of services, including domiciliary care, short breaks in the community, adaptations, and so on. The duty then to accommodate disabled children and other children in need is found in Section 20 of the Children Act 1989, and in particular in subsection 1, a duty where families are at crisis point and can no longer provide suitable accommodation or care arises. And that's a whistle-stop tour through essentially Chapter 3 of Disabled Children, a legal handbook on the social care scheme. And the key point for present purposes is that none of that's changed, because all of that is outside the scope of Section 42 of the Children and Families Act. And so if a disabled child was entitled to social care before the current crisis, they remain so entitled. And in situations if they're not getting it, they will need advice. So that's what we were going to say by way of initial presentation. I think we're now going to switch to the Q&A. Tom, I'll stop sharing my screen so I can see you. I actually flagged a few questions rather cheekily earlier that I thought I might ask you first on the timeframes point, if that's okay, and then you can have your revenge by asking me any questions on the notice. Is that all right as a,
yes, of course,
process? The first group of questions I flagged, and you did very helpfully tackle it in headline terms already, was the retrospectivity point, because a number of people have raised points about processes that are halfway through when the regulations kick in. And so perhaps rather than asking about anyone's particular facts, which would obviously be inappropriate, is there anything more you can say about where, for example, an annual review took place before the 1st of May, but the amended plan hasn't been produced? Does the coronavirus exception potentially apply to the production of that final plan? Or because it all started before the 1st of May, are the local authorities still bound by the old strict timeframes?
That's a very good question. I would have, and there is some vagueness, I think, in the government's description of what the regulations are doing on that. What I think this gets at, and this is quite a potentially important point, the guidance seems to suggest that the coronavirus exception, so the delay exception, however we want to describe it, is potentially available for each and every separate stage of the process. So it doesn't just bite for a very long process, such as the 20-week deadline, but any individual steps within that could also possibly give rise to the coronavirus exception if those grounds can be shown to apply. So I think the unfortunate reality is it's not crystal clear, but if there was a process still underway at the time the regulations came into effect, and that bit of the process arguably needs to be delayed because of coronavirus, then the delay excuse grounds, however you want to describe it, will apply. I think that's right. The answer I can give.
Yeah, that's very unfair of me to ask you that, because it's really tricky, and I should say I agree with you, so I'm going to take shared responsibility for that answer, because I think it is a really difficult point. It probably also throws up, frankly, that this has all been done in a rush for understandable reasons. And it may be that some of these really tricky questions haven't been very clearly thought through. Because as you say, the guidance I don't think really helps us on that, does it?
No.
So maybe that these have to be worked out on a case-by-case basis, I'm afraid. You want to retaliate, Tom, and ask me one, or did you have something more?
Retaliation, but it's a theme that's come through in some of the questions, which I think is interesting, and it's something that I can see might become an issue down the line. So some of the questions have asked, in effect, once things do start to return to some semblance of normality, and once these legal, the amendment notices or the notice that you've addressed is no longer in force, what would be the position for parents who want to say there's been a backlog, as it were, of provision that we've missed out on because of coronavirus? Are there grounds for them arguing that that should be made up, for example, through additional therapy input once life has returned closer to normal?
It's a really interesting question again, isn't it? I think probably strictly no, in terms of the Children and Families Act scheme. I think that the requirement will be to carry on securing the provision, and it will magically transmogrify back into an absolute duty, we understand. But it may be that local authorities will have to think about doing that, at least in accordance with some of their broader duties. So, for example, the duties to safeguard and promote children's welfare under Section 11 of the Children Act 2004 and Section 175 of the Education Act 2002. Now, those are have regard duties. They're duties that, as you know, talk about thinking about needs rather than actually doing something. But they will at least have to consider any request for top-up or backdating. The other point, of course, unfortunately, is that children and young people's presentation might deteriorate over this period. And so there might need to be a review of the plan in order to see if the provision in it is still adequate. It might, or appropriate, I should say. There might need to then be more provision to make up for the fact that the things haven't been done. And when you start to think about these points, it becomes increasingly clear to me, at least, that it's just a really bad idea not to provide for children and young people with SEND who have these entitlements. And it's a really bad idea when you look at it from a welfare point of view and a children's rights point of view, or if you just look at it in a very utilitarian way, very essential way, in terms of good administration, because it's going to be chaos, isn't it? If we come back in September with the full scheme of rights and entitlements as we're promised, and yet there's all these children and young people who haven't had things done, whether that's the process points or the substantive points, it's going to be an absolute nightmare for everyone concerned. And I think I just encourage everyone on this webinar and all those in the system at all the different points to do their very best. It was interesting that the Labour front bench tabled an amendment when the bill was going through that would have made the duty in the notice an all practicable steps duty, which essentially means do everything you can. That didn't get adopted. That's not the law, let's be clear. But I think it would be great if people behaved as if it was the law, because that kind of approach that says just really try, do everything you can, as opposed to just do what's reasonable, and that's potentially a lower threshold, that might avoid these kind of problems that we're picking up.
Yeah, I think if I could, there are a couple of themes that have come through.
Please.
The questions, obviously not to address them all, but two things I think are worth addressing following on from my presentation. The first is a question's been asked about if, for example, a new request is made for an EHC needs assessment, do the changes mean that the local authority don't need to do that? And I'm only focusing on that particular question because I think it illustrates again the point that runs throughout my whole presentation. The answer is no, there's no change to the substantive duty, and the legal tests that trigger each and every stage of the process are still in effect. The change is to the timetable that would apply to that. The deadlines do still stand, but they are able to be relaxed where the exception applies. So that was the first question that I noticed. The other is about several people are asking, how does the local authority actually evidence the exception? So if they're going to rely on it, what does that actually mean in nuts and bolts terms? Well, I think, applying basic principles of good administration and public law, evidencing means that it needs to be clear, first of all, that is what the local authority is doing. So that if the deadline is going to be breached, then parents need to be notified of that. It simply shouldn't be something that happens and is then sought to be challenged. And I would have thought that it's unlikely to be good enough simply to say, because of coronavirus. I would have thought it is safer in terms of local authorities shielding themselves from legal challenge, and fairer in terms of giving parents reasons to have adequately reasoned decision letters which explain precisely why it is the process has been held up because of coronavirus. And I think it's probably in both sides' interests to try and produce reasoned decision letters. So that would be my response to the how do you evidence this questions that we've received.
That's really helpful, Tom, and I'd completely concur with that as well. And it's just good practice, isn't it, that there's a need to show your workings, and even more so when you're being invited to exercise some quite controversial measures, frankly, and measures that have caused real concern. Needs to be done very carefully. I'll pick up two as well that have come in that I think are quite interesting and of broad interest. The first is a question about the risk assessments in relation to children with EHCPs going back to school. And the question is that an annual review by another name? The answer is no, it's not. It's a very specific approach that's set out in different guidance, I'm afraid. There's so much guidance at the moment, isn't there? Which requires there to be a risk assessment, essentially as to whether the child or young person is better off in school or college or at home. And that's the, very crudely, the question that's being asked in that risk assessment. Where is the risk to them less? And obviously then the decision as to where they go should follow. But that's a practical approach that's being adopted as opposed to really any legal guidance. And it certainly wouldn't amount to an annual review of the child or young person's EHC plan. And a question about information for parents. Should local authorities specifically inform parents that they're using the exception? I think so, yes, but at an individual level. Because this isn't like, for those who are aware of the adult context, the Care Act easements guidance, which each individual local authority has to trigger and say, we are now operating under stage 3 of a process that's set out in the guidance, and we are no longer complying with the full Care Act duties. The regulations and the notice are enforced generally, in England, I should say, because there was a question about Wales a moment ago. And you don't have to do anything as a local authority or a CCG to rely on them. But as Tom's helpfully made clear, and as the guidance says, people need to be informed, and the guidance is really clear about that. So it would be an individual decision. It's absolutely an individual decision under the regulations, as Tom's shown, because you have to show that in that particular case, the coronavirus exception applies, and you can't do it in the normal timescale. Under the notice and the Section 42 duty, it's not strictly legally an individual decision, but the guidance makes clear you have to give individual reasons to that family as to why things are being done differently. So that's a very long way of saying yes to the question, which was, should local authorities inform parents they're using the exception? Anything else you've picked up, Tom?
No, I suppose one thing is around how we should best think of the coronavirus exception for the procedural points. And I have at times in my slides referred to it as an excuse. That was not intended to be pejorative, and I did give quite a bit of thought as to how it should actually be described, because it is an unusual provision. It seems to me that the various deadlines do still stand. They themselves haven't been modified, but it does create additional grounds or an excuse for delay where it applies. So I think that's the way to think of it. And again, this is potentially very radical, but there were already grounds for missing deadlines under the previous regime. So it's an additional set of grounds that are laid on top of the existing ones. That was one particular thing that I noticed in the questions.
There's been a few questions in, Tom, about the legal definitions here. I think we should have a go at this. So there's a question, I think, in Northern Ireland, it's best endeavours, if I've understood correctly, as opposed to reasonable endeavours. And there's quite a lot of law, I think, in other contexts about the difference between those terms. To have a stab at that, best endeavours means, you'll be surprised to hear, you have to try your best. You have to do the best you can to make the thing happen. Reasonable endeavours means you have to act reasonably, and allows, I'd suggest, a greater degree of leeway in terms of not doing the thing or doing the thing in a different way. And I think reasonable endeavours is pretty low, really, in terms of enforceability or challengeability it's a duty to do what's reasonable, and as people will know, what's reasonable is a matter for the decision makers, subject to falling outside of the range of reasonable responses. So it's not a do nothing duty, clearly, but it's less significant than all practicable steps or best endeavours or other terms that are used in other contexts. Is there anything you want to add on that, Tom?
No, I think the only, it's more of a question than anything else, or a query, is whether what is regarded as reasonable. It's obviously going to be fact specific and it will vary depending on the circumstances, but whether there might be an area by area flavour to that. So if there are particular local authority areas, parts of the country which are very hard hit by coronavirus, and there is more disruption to healthcare provision, to schooling, to the delivery of special educational provision, whether it might be more reasonable for an authority in that area to say what we've done reasonably is a lower threshold than it might be where somewhere is less well affected. And it seems to me that's probably an open question which is unlikely to be answered until decisions start being taken by the courts on this, or we get further and more detailed guidance from the government as to how the test is to be applied on the ground.
Agree with all of that. We've had what I think is a really excellent question about the approach that should be taken to writing EHC plans at the current time. Should the plan include both what is needed now and what's going to be needed post-COVID? That's difficult, isn't it? I think probably yes, bearing in mind that plans are supposed to last a year. The needs, of course, of the child or young person shouldn't change. The provision might change, but I think the better approach might be to specify and quantify the provision that would normally be needed, and then perhaps to record what is actually going to be reasonably deliverable at the current time. Do you have any thoughts about that, Tom?
No, I think only really to add to what you have said, and I think to flag up that there are going to be a lot of questions about what needs to happen when the current legal regime comes to an end. So there have, for example, in the topics I've covered, been questions about what happens on 25th of September if the government doesn't decide to renew the regulations and they simply lapse. Well, I think in those circumstances, we are going to be back to the normal deadlines. There aren't going to be additional grounds on which to delay. But that's going to be very difficult for transitional processes that are caught at that cutoff point. And I certainly, based on my reading of the guidance, probably because, as you say, Steve, it was produced in a hurry, I haven't found anything that even comes close to answering that question. But clearly there is going to come a cutoff point where these decisions are going to have to be addressed.
Can I raise the point about direct payments? Very interesting question, I think, across the piece, actually. And of course, the Children and Families Act extended this principle of direct payments to education, although it's quite hard to get an education direct payment because essentially it has to not cost any more than making the provision in another way. But that might suddenly be a relevant factor, mightn't it? Because if the provision isn't available any other way, but a direct payment would allow for the provision to be made, it might be said that that's a reasonable endeavour. Would you agree?
Yes, I think it would. And without wanting to tread too much on your toes, it seems to me that the thrust of the guidance that's been produced on the reasonable endeavours point is to encourage, as you say, what's called co-production, but also to encourage creativity in delivery of provision. And it may very well be that if direct payments is a quicker, more creative, more direct way of securing provision during this health crisis, then that right there is a reasonable endeavour that should be taken.
And I think that might well apply across the piece. I've done some work on how social care and health direct payments could be used appropriately to fund family members to provide care at the current time, which is permitted under the regulation, where it's necessary, essentially. And when could it be more necessary than now? So I hope that the flexibility will work both ways. That's I think the key point I'd like to perhaps leave us with, because I'm conscious of the time, that the requirement for flexibility is obviously a system-wide requirement, and if parents and young children and young people are being required to be flexible and not to assume that they're going to have everything they've always had in the same way. It would seem to me appropriate that local authorities and CCGs are equally flexible, and where creative solutions are being put forward or novel solutions, that there's a can-do kind of attitude rather than a can't-do attitude, and that hopefully that strong message in the guidance about co-production will work, and there will be opportunities for new ways of doing things, like, for example, hosting webinars rather than doing these talks live, that actually become more accessible to people in many ways. We'd never have been able to get 500 odd people in a room to have this talk. So I hope that in a much more challenging environment of actually providing services to children and young people, a similarly flexible approach might be adopted. Tom, did you have any last thoughts or comments you'd like to make?
No, I don't think so. I think the comments you just made, Steve, are a good summary of the situation we're in, the challenges, and the legal duties and how they've been amended.
Great. Well, we have had still a host of questions that I'm afraid some of them I haven't even seen because they've kept coming in, but others I know I've seen and we've not been able to answer. Apologies for those we've not been able to answer. We've covered as many as we can. We've been rattling away between us to try and type out some answers too. We'll see what we can do about whether there's a way of answering any of the others that remain outstanding. And I think that would also apply to those that came in advance. I'm afraid that hasn't been possible for us to address those either. So we'll see if we can find a clever way of dealing with that. And thank you otherwise, everyone, for joining us this morning, now this afternoon. We really hope it's been helpful. And as promised at the beginning, the slides and the recording of the talk should be available on the 39 Essex Chambers website imminently, thanks to the fantastic marketing team. And I presume that if you signed up and registered for this, there'll be an email alerting you of that fact. I hope I'm not over-promising there. If I am, it will be on the relevant page of the website shortly in any event. Thanks very much, Tom, for the very helpful analysis of the regulations. And thanks very much for everyone for joining us. We've still, even though we've gone over time, we've still got over 400 people on the line. So that's fantastic to see the interest in this area, and hopefully working together, everyone can make sense of this very challenging situation.
Thanks, Steve.
Thanks, Tom. Thanks, everyone. We're going to bring the webinar to a close now. Thank you.